Well, good afternoon again for the second time, and welcome to this, the fourth in Cornerstone's Housing Week of webinars. As indicated earlier, my name is Dean Underwood, for those of you who don't know me, and I'll be chairing today's session. And today we'll be talking to you about public law and discrimination challenges to possession claims, providing you with an overview of principle and practice and an update about recent developments in this area. Now, since their humble beginnings back in 1985 in the case of Wandsworth, London Borough Council and Winder, public law challenges to private law possession claims have become somewhat of a common feature in civil litigation. I dare say many would agree, especially from a landlord's perspective, not too infrequently a costly thorn in the side of public sector landlords. Registered providers seeking possession of the homes of secure, assured and even mere contractual tenants, often faced with the type of challenge that one would ordinarily expect to see in the administrative court. Challenges, for example, premised on a landlord's failure to apply or have regard to a policy, for example, an antisocial behaviour policy or a policy on vulnerable persons, on its failure to take relevant matters into consideration when making possession-related decisions, and, for example, taking irrelevant matters into account in that process. Over the years, I think it's also fair to say the number and type of permissible challenges to possession actions on a public law basis has increased, from those based, as I just discussed briefly, on a traditional judicial review basis, to alleged human rights breaches contrary to the Human Rights Act 98, to discrimination defences and counterclaims under the Disability Discrimination Act 95 and its successor, the Equality Act 2010, and breaches of statutory duty, including, of course, the public sector equality duty, a common feature in modern public sector possession claims. Today, for your convenience, we'll consider each of these types of challenge in overview, and we'll provide you with tips to avoid what, to use an obvious lawyer's in-joke, I've come to call the public law sidewinder. See what I did there. Delivering that talk today will be Cornerstone's 4 Rs. I have to be very careful how I say that. Ryan Kohli, Riccardo Calzavara, my roommate, the 3rd R, Andy Lane, and last but by no means least, Rowan Clapp. 4 more experienced and eloquent speakers you could not hope to have. No pressure, guys. Ryan's going to consider the vexed topic of discrimination defences and counterclaims to possession actions. Riccardo will speak about public law challenges more generally. Andy is going to consider a topic close to his heart, I know, the public sector equality duty. And Rowan finally will take you through an overview of recent case law in this area. I'm going to return later to host a short question and answer session based on your questions throughout the talk, so please don't hesitate to post questions in the chat forum. Before I hand over to Ryan, it would be remiss of me not to mention the team's hard work on recent and expected publications. So if Rowan can fast forward on the slides to the book slide, thank you. We have work on my part on mandatory, additional and selective licensing ongoing. Coolgit has recently published the latest edition of Cornerstone on ASB, a very successful tome. Andy's working on the equally successful 2nd edition of Cornerstone on social housing fraud. And of course, we have Cornerstone on information law for all your data protection needs. In short, whatever your housing law needs, we will have either a barrister and or a book to meet it. So don't hesitate to instruct us, a shameless plug for work. On that note, I will cease here and I will hand over to Ryan for what I'm sure will be a very informative talk to begin with on discrimination defences and counterclaims. Ryan, over to you.
Thank you very much, Dean. And just to say to everybody, if you've got questions, there is a question and answer session at the end of our talks, and if you type your questions into the Q&A section in this webinar, Dean is going to be assiduous in compiling your questions and will be answering them at the end, so don't forget to do that. Well, moving then to my first slide, just to give you an indication of what I intend to cover, a few introductory remarks to start with. Equality Act defences obviously remain an incredibly active part of any solicitor acting for a local housing authority or RP. it always amazes me when judges become fascinated by the fact that local authorities or RPs are trying to evict somebody who on the face of it has quite serious vulnerabilities. But of course, and it often is quite effective to remind judges gently that those who occupy social housing, whose landlords are local authorities or registered providers, are there precisely because they've got a vulnerability of some sort in many cases, or a disability of some sort, again, in many cases. And therefore, courts shouldn't be surprised that those are the very tenants who are ultimately the subject of a possession action and who landlords might have to obtain a possession order against, even though it's clearly the last resort in every case. Well, what I want to look at today is just the tools that exist for you to be able to defend these claims successfully. So first of all, it is important to understand precisely what it means to have a disability within the meaning of Section 6 of the 2010 Act. I will then go on to look at what constitutes discrimination before finishing off with how to deal with Equality Act counterclaims. So moving to the next slide, looking at the definition of disability. Now, many of you will have looked at this before, but it's always a good idea to recap. A person has a disability for the purposes of Section 6 of the Act if they have a physical or mental impairment, and that impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. Now, there are many terms within that are defined later on. So firstly, under Schedule 1, we know that the effect of an impairment is long-term if it has lasted for at least 12 months, or is likely to last for at least 12 months, or is likely to last for the rest of the life of the person affected. And if the impairment ceases to have a substantial adverse effect on a person's ability to carry out normal day-to-day activities, it is to be treated as continuing to have that effect if it is likely to recur. So when looking at the issue of whether the effect is long-term, the litmus test is, has it lasted for 12 months? Is it likely to last for 12 months? Or is it likely to last for the rest of the life of the person affected? So next slide, please. Thank you. The example given in the explanatory notes of the 2010 Act is pretty instructive. A man with depression finds even the simplest tasks or decisions difficult. For example, getting up in the morning, getting washed and dressed. He's also forgetful and can't plan ahead. Together, these amount to substantial adverse effect on his ability to carry out normal day-to-day activities. And because he has experienced a number of separate periods of depression over the period of 2 years, which have been diagnosed as part of an underlying mental health condition, that impairment is therefore long-term within the meaning of the Act. So the explanatory notes are quite often a good place to start if you've got a case before you and you're wondering whether the conditions that the individual has constitute disability for the purposes of Section 6. There are, of course, certain exclusions from the definition of disability. Those are set out in the Disability Regulations Order. I just highlight a couple for you here. Addictions to alcohol, nicotine, or any other substance, such as Class A drugs, are not treated as amounting to an impairment for the purposes of the Act. But that doesn't apply where the addiction was originally the result of something that had been medically prescribed or other medical treatment. Now, what's important to pick up on here is even though the addictions themselves are not disabilities within the meaning of the Act, if the addictions give rise to secondary conditions, such as depression, in the case of alcoholism, for example, then that would still be a disability within the meaning of Section 6 of the Act, so long as the other criteria were satisfied. Moving to the next slide, and that first bullet point is precisely what I've just outlined. Moving to the definition of discrimination, so on the previous slide, please. Section 15 of the 2010 Act addresses discrimination arising from disability. So many of you who are familiar with the Act will know that there is a special section dealing with discrimination arising from disability. It doesn't come within the purview ordinarily of the ordinary disability section. There is a specific section dealing with discrimination from disability, and that is Section 15. And we know that a person A discriminates against a disabled person B if A treats B unfavorably because of something arising in consequence of B's disability, and A cannot show that the treatment is a proportionate means of achieving a legitimate aim. And of course, that provision doesn't apply if A can show that A did not know or could not reasonably have been expected to know that B had the disability. So just looking at this section for a moment, again, many constituent parts. You're looking for unfavorable treatment because of something arising in consequence of disability, and you're looking at what it means to be, what it means to have a proportionate means of achieving a legitimate aim. So moving to the next slide. Those are the key terms. The key concepts here are unfavorable treatment. That could be, for example, the service of a statutory notice, a notice of seeking possession, or a notice to quit. It could be the service of demotion proceedings, possession proceedings. Unfavorable treatment has a very large category. Something arising in consequence, well, those are the actions of the tenant. The actions leading to the unfavorable treatment must have arisen because of the disability. So there must be a causal link between why the local authority or RP is taking possession and the condition of the individual. So for example, if somebody is paying, if somebody ceases to pay rent, and the reason that they're ceasing to pay rent is because they're putting their head under the sand owing to their depression, and that results in a notice of seeking possession being served, well then all of the elements there are satisfied. The unfavorable treatment is the notice of seeking possession, and the something arising in consequence is also satisfied because of course it's the failure to pay rent connected with the depression. Now, thinking about the justification for why that notice of seeking possession might be served, of course, you're looking at whether the action that you've taken in serving that notice is a proportionate means of achieving a legitimate aim. And this is, as I say, where most cases are won or lost. And that's why it's important in every case where you have a disabled tenant that you keep a record, or your officers keep a very careful record of what actions they've taken in the lead up of taking the unfavorable treatment, whether that be the notice of seeking possession or the issue of possession proceedings. The court will want to know at each stage that you have tried to avoid getting to the point of actually issuing proceedings or serving that notice. So what other steps, what lesser steps have you taken to try and address the point in the first instance? For example, if the rent arrears have arisen because of the head in the sand owing to a failure to complete housing benefit forms, have you tried to assist them in getting their housing benefit forms in? Have you signposted them to the relevant agencies? Have you made that extra effort to make contact with them because you know or highly suspect the reason that they're putting their head in the sand is something to do with depression? So this question of proportionality is very relevant when it comes to establishing that you have a justification for taking the action that you are. So moving to the next slide. The case of Astor Communities and Ackerman Livingston is key to understanding the question of proportionality. Lady Hale at paragraph 31 provides that no landlord is allowed to evict a disabled person because of something arising in consequence of their disability unless it can be shown that the eviction is proportionate. Therefore, and she says this quite clearly, we as local authority landlords or registered providers must show that we've given consideration and we must be more considerate to a disabled tenant than a non-disabled one. There must be a structured approach which involves considering lesser measures, and it requires a balance to be struck between the seriousness of the impact on the tenant and the importance of our aims in recovering possession. You'll see there that the structured approach is derived from European Union law, the case of Elias, where Lord Justice Mummery held. First, it's important to consider, is the objective, so that's possession here, sufficiently important to justify limiting fundamental right? Secondly, is the measure rationally connected to the objective? And thirdly, are the means chosen no more than is necessary to accomplish the objective? And so if you are keeping a careful note of all those lesser steps before you've got to the point of issuing the notice or issuing proceedings, and those lesser steps are proportionate at each stage, and then the issuing of proceedings themselves are proportionate, then that is a good start. That is a good way to persuade the court that as a proportionate means of achieving a legitimate aim, that you are taking possession proceedings. So on to the next slide. So if the court finds that the landlord has discriminated against the tenant by evicting them, then they've got the court has the power to award damages, and that comes under section 119 of the 2010 Act. The remedies that are likely to be sought by a tenant once discrimination is established is a declaration that they've been discriminated against and also damages. I won't spend too much time on discrimination counterclaims because it really follows from a finding of discrimination. So this will only be relevant if there's been a finding of discrimination. The way the court works out damages is on what's known as the Vento scale. That is a scale that goes from the least serious cases to the most serious. The least serious are those where the discrimination is a one-off or isolated occurrence. If we look at the next slide, the middle band applies to serious cases that don't fall within the higher band, and then the higher band applies to the most serious cases, for example, where there have been a lengthy campaign of discrimination and or harassment. Now, all the local authorities and RPs that I know do not engage in lengthy campaigns of discrimination or harassment. So if there is likely to be a damages award, it is likely to be in that lowest first category. There is a scale that's issued every year by the Secretary of State. The current scale applies to claims issued on or after the 6th of April. It has a lower band of £900 to £9,000. So that is the bracket within which you come if, generally speaking, if in a possession claim, a court does find that you have discriminated against the tenant by bringing those proceedings. So that's it was a very quick canter through the law. I hope that gives you a bit of a handle on both the basics and how to build up your case to make sure that in each case your unfavourable treatment is proportionate. And if you do get to the stage of needing to understand what sort of damages the courts are going to award, then you know where to look for that. And without further ado, I will now pass on to Riccardo, who's going to talk to you about public law challenges.
Thank you, Ryan. I'm going to be talking about public law challenges, particularly in the context of defences to possession claims. Start my first slide, please. These sorts of challenges come from the principle that public authorities must act in accordance with the law. So, generally speaking, public bodies, defendants, and they apply to most social landlords, which is the ratio in the Weaver case, which is the first on that slide. But that doesn't mean that they apply to all social landlords in every context. And that's what the McLeod and Peabody case was about. So for example, in that case, Peabody's refusal to allow the claimant to assign his tenancy hadn't been the exercise of a public law function and was not therefore susceptible to judicial review. And the important points were, in that case, that the properties hadn't been purchased using public money and Peabody had no allocation relationship with any local authority. So all that to say, it's not a given that a private registered provider will be a public body in the sense that it can be made susceptible to a public law defence. On my next slide, please. How do these challenges arise? Well, they're normally seen in assertions that a public body has acted in one of these ways. So most of them will be familiar and obvious. The first is acting outside of their power. And the last is the classic Wensbury test, which is designedly high, that the authority reached a conclusion to which no reasonable authority properly directed could come. Can we move on again, please? So the question is, where do these challenges come from? And as Dean said in opening, they used to arise as standalone judicial review claims. But the problem with that was that it meant there was duplication of litigation. Because, for example, if someone wanted to challenge a decision to bring a possession claim, she couldn't run that point in the possession claim, but instead had to go to the admin court to have the bringing of the claim quashed, which was a waste of time and money. So as long ago as 1985, in Winder, the House of Lords recognised that it was permissible to challenge the decision to bring a possession claim on a public law basis within that claim itself. Now, Winder had been a straightforward case in a sense because it involved a secure tenant, so tenant of a local authority, tenant of a public body. K was the later case, the next case in that chronology, that broadened the principle so that public law challenges could also be used by those who didn't have a private law right of occupation. So it was a big deal because the effect was that even if the private law couldn't protect your right to stay where you were, you could avail on public law to do so. Can I have my next slide, please? And then we have the now no longer quite so recent decisions of the Supreme Court in Pinnock and Powell. They're both important, well known, and no doubt known very well to you all, and full of relevant findings. But for now, suffice it to say that Pinnock is authority for the proposition that even if the statute says that a possession order must be made if the technical process, in that case, section 143D, I think, of the Housing Act 96, is carried out, the court still has jurisdiction to consider whether it's appropriate and proper to do so as a matter of public law. And Powell, for these purposes, is authority for the proposition that you can use the possession claim as a forum in which to challenge decisions that precede the bringing of the claim. So again, in that case, service of notice to quit itself. Can I have my next slide? I wanted to look at the sort of mistakes that social landlords can make. And there are a few examples in this slide and the next one. The first case that I want to look at is McGlynn. In that case, the authority had said in a letter that it had sent to the tenant that possession action would not be taken unless it, the authority, was satisfied that there had been a significant breach of the tenancy. They served notice to quit and a year later issued their claim. And the Court of Appeal found on appeal that it was seriously arguable that in light of the policy as set out in the letter, a reasonable authority wouldn't have issued possession proceedings without being satisfied of a significant breach. And the message from that case is that you should check whether you're happy to stand by assertions of what you'll do before sending a letter. And if you've sent letters, you should check their contents before taking further steps. If McGlynn was a policy by policy or policy by letter case, Barber was a policy by policy case. And the policy in that case said that the authority would refer complaints of antisocial behaviour to the mental health service where the perpetrator or the alleged perpetrator was vulnerable, and they didn't. The Court of Appeal overturned the possession order. The message in this one is easy: follow your policy. White was a rent arrears and antisocial behaviour case. There was an internal appeal and the landlord said that it would offer a fresh one because it hadn't provided the tenant with all the information, and it didn't. And as a result, the possession claim was dismissed at first instance in the High Court. The message there is, don't promise rights you don't deliver on. My next slide. Shearer was a failed successor case. The respondent to the appeal, the defendant, was the wife of the deceased tenant, and she was a failed successor who made a Part 6 application saying that she wanted to stay in the house. The landlord local authority decided to bring a possession claim against her, to which she responded the authority should have considered whether to exercise its exceptional power to make a direct grant to her of the property. In that case, the Court of Appeal upheld its dismissal of the claim. And the message from that case is, check your policy. Ms. Sherritt may well have challenged the local authority for deciding not to make a direct grant to her, but the authority would have been in a better position actually having considered that question. And I know Andy's going to mention Davies, so I'll leave that to him. Can I have my next slide? Unlike in a JR, a public law defence to, for example, claim for possession has no permission hurdle, which means that you can see unmeritorious public law defences. But in appropriate cases, those defences should be stopped, either because they don't suggest that the claim is genuinely disputed on grounds which appear to be substantial, or because they should be struck out for the normal reasons, CPR 3.4. A good case to have in your arsenal is the first I list in that slide, which is Corcoran, which criticised public law attacks of a technical and over theoretical nature. I've listed Patrick there, but I know that Rowan's going to address it, so I'll leave that as well, if I may. And then if I could have my next slide. I want to look at the standard to which these sorts of defences must be proved, and there are a few important cases. The first is Norton, which was a caretaker case. A possession order was granted, notwithstanding the local authority's failure to consider the daughter's disability, and the Court of Appeal held that a mere breach of the public law right would not suffice. That breach had to make a difference to this decision, and that's the sort of starting point of many of these, what I've called defences to public law defences. Ahern is Dean's case. The possession claim was defended alleging failures to comply with policy. The landlord asserted that it was aware of the tenant's vulnerabilities, that attempts to assist him had been fruitless, and that the landlord had consciously considered the effect on the tenant of being made homeless. The Court of Appeal dismissed his appeal against the possession order on the same basis. Davies, again, I'm going to leave for Andy. I know that he likes to talk about it because we were on opposite sides and he won. Eels is a case that was defended on the basis that the antisocial behaviour that was alleged was caused by the tenant's disability, and an injunction would have been a more appropriate remedy. It was alleged that there had been a breach of policy in the failure to refer the antisocial behaviours to the vulnerable persons panel. And the High Court dismissed an appeal against the possession order. Bringing the claim had been justifiable. It wasn't necessary to seek an injunction. My next slide. Again, I know that Andy has this on his list, and I see that he's added see Andy's section to my slide, so I'll see Andy's section and let him talk to you about forward. And then my last slide, please, is my summary slide. Here's my crib sheet, which you've all now got access to. I hope it's self-explanatory, and I will, with no further ado, pass over to Andy.
Thank you very much, Riccardo. And what you may not know is that Dean has said we've got 10 minutes each, and that he's going to crack the whip, whatever that means, which means that I've got 40 seconds of slides, so I'm not going to take too long on each slide. But I would say on the public sector equality duty, it is something I actually volunteered for some reason, which I'm not quite sure why, because it's a defence to possession claims, and obviously we're looking at it in that context, which invariably annoys me. It's rarely properly pleaded. It's often an add-on, as Powell, for example, Dacorum and Powell, only after other more obvious defences have been jettisoned. And it's often left on its own, and we'll see with Hertfordshire and Davies, without any obvious merit at all. But what I would say about the PSED is that we are in a lot better position in terms of clarity and knowing where we are in respect of possession claims than we were a couple of years ago. And the other thing I would say is that we are also dealing with something that, even if you've breached it, unlike the damages that Ryan was talking about in the context of discrimination, doesn't actually lead to any other sanctions. In other words, there's no damages claim available in respect of that. In terms of the slide you can see in front of you, it's a useful starting point. I mean, Mr. Justice Turner is a very well-known judge. He's had a very interesting recent history in terms of his first lines of judgment, with some interesting entries into that competition. And it's also something that Dean is very well aware of, having been in front of him in Poplar, Harker and Begum. But he is incredibly bright and incredibly helpful in this area, because he has really set it out very clearly. Now, I'm going to look at section 149 itself in the next slide, but you can see from this slide that the PSED, whatever I say in terms of how it's dealt with in defences, is an important duty. So whatever I say is not intended to undermine that fact. And it also, of course, as you can see from the second half of the second quote from Mr. Justice Turner, looks at not just, of course, the needs of the defendant or the defendant's household, but also looks at the countervailing factors, such as, of course, the neighbours, etc. in an ASB case, the ability to continue without having your rent paid in other instances, and so on. So it is an important thing. And paragraph 42, if you don't read any other case, and if you don't read any other part of a case, I would strongly recommend you read paragraph 42, which I'll come on to in a slide in a summary version shortly. But paragraph 42 of the judgment is a must read, because it will take you through, which is useful for me, an idiot's guide to the PSED and how to approach it. So if I can have the next slide, please. Thank you very much, Ryan. The PSED, well, it's going to be 1A, 1B, 1C. I do remember saying to somebody once in an appeal, I think it was Powell actually, well, which one is it? You know, you've put it down there as your defence, saying that we have breached the PSED. Well, what have we done? Have we not had due regard to eliminate discrimination, to advance equality of opportunity, or to foster good relations? Which one is it? And often that question puts people on the spot, because they haven't really considered it. The public sector equality duty is not the same as discrimination. So in principle, and indeed in practice, of course, you may not be discriminating against a tenant or a household member, but you could still be in breach of the public sector equality duty. It is a duty, after all, to have due regard to certain issues. It's not equally going to be normally dealt with by way of a proportionality assessment, because if you're doing one of those assessments before you issue proceedings or at any stage thereafter, that generally is in respect of discrimination again. It will help, but it won't necessarily demonstrate the due regard to 1A, 1B and or 1C that is required. And one can see from a case that you may have come across, which is Luton Community Housing Trust and Dodana, which Rowan will look at in a bit more detail, that as an example. But what it is, it's not about outcomes. It's not about saying, well, what you should have done is this. It's about whether you actually had due regard. And therefore, if the court is of the view that you did, whatever their view of what you should have then done, that is sufficient. It's about demonstrating you've had that due regard. Now, some of these concepts, A, B, and C, are explained later on in section 149, and we'll have a look shortly on the next slide about one example of that. And subparagraph 5, incidentally, deals with the question of fostering good relations. So there are there is help in the legislation as to how to interpret 1A, 1B and 1C. And I also ought to say, before we move on to the next slide, that it's not just about disability. Now, the reality is that most claims that we come across are to do with disability, because that's one of the obvious protected characteristics. And for example, with disability or even rent paying or housing benefit or housing cost claiming, people's mental health or even physical health in some instances is going to have an impact on that. But there are, of course, the other protected characteristics, which you'll see, and it's listed in subparagraph 7, which is the age, the disability, the gender reassignment, the sex, sexual orientation, etc. So there are those other provisions. And you'll also see subparagraph 6 on the screen in front of you. It does actually say that it may actually allow you to treat some people more favourably than others in order to make sure that they're not at a disadvantage. So, for example, you may, in a rent case, decide that in a particular case you're going to do a home visit, whereas normally you wouldn't do, but this person may benefit from that because maybe they're depressed or maybe they have some issue, which means that they're not very good at dealing with things and engaging with their landlord. So sometimes you're perfectly entitled to do that. And although, of course, you're not entitled to directly discriminate, and that's section 13, even section 13 allows you to exercise more favourable treatment in the right circumstances to disabled persons. And of course, there's also section 158, which allows positive action to be taken. So if we can have the next slide, Rowan. This is what I was referring to as an explanation of the previous slide, which was looking at equality of opportunity. That's section 149. 1B. And you can see there, looking at A, B and C on this subparagraph, removing or minimising disadvantages suffered by persons who share a relevant protected characteristic, etc. So as I say, giving people a named point of contact. I've had several cases recently where somebody is bombarding the landlord with queries, with emails, etc., etc. And maybe that is in part down to their mental health condition. And maybe one of the ways of dealing with that is giving them a point of contact, which may assist. Similarly, communicating by text, communicating by visits, communicating via support workers or family members are other ways in which you might demonstrate that. And of course, therefore, when you're looking at the public sector equality duty, you're just trying to see whether you've had regard to those issues. It's not enough, therefore, to say, for example, you've got rent arrears and therefore we're going to proceed, let's say, with an assured tenancy under ground 11 and therefore discretionary, because the obvious question is going to be, but you knew that they were depressed and you knew that they were unable to engage because of their mental health condition. What did you do about that? Did you have a think about that? And if you can say, yes, we did, but unfortunately it wasn't successful, then that's fine. So looking at the next slide. Who is covered? Well, public authorities, of course, are covered. They're defined and set out at Schedule 19. Section 150 just refers you to Schedule 19. But also people exercising a public function. And Riccardo's already dealt with the McLeod case, which was one of John Holbrook's cases. And we've also, of course, got the Weaver case. So in general terms, and as Dean has indicated at the start, local authorities, of course, in large part for most of their functions, and housing associations in most of their possession claims, unless there is something particular about that. Some of the intermediate rent cases, for example, may be arguable, but generally speaking, certainly for the purposes of this webinar, we'll just assume that they are covered as much as local authorities. So next slide, please. I've cited Bracking because everyone else does, so why shouldn't I? When people start pleading these claims and start arguing that they should have a good defence, they often quote cases such as Bracking, which is an appeal against the decision upholding the Secretary of State's decision to close the Independent Living Fund. And it found against the Secretary of State and found that they hadn't produced sufficient evidence that he had had regard to the public sector equality duty in reaching his decision. So the court wasn't concerned about should you have closed the Independent Living Fund or shouldn't you? Did you think about the consequences? Did you have the due regard? And you can see I've numbered 1 to 8, which I won't go through them individually. Some of the issues that arose from that case, including, you can see, number 1, record the steps taken by the decision maker. And that's obviously crucial. But this is going to be with you, of course, and you'll be able to refer to that. But if we have a look at the next slide, I referred earlier to Mr. Justice Turner's reference, an up-to-date reference of paragraph 42 to what one should do in the context of possession claims. And this is incredibly useful. And you can see from this, it effectively rephrases Lord Justice McComb. Public sector equality duty is not a duty to achieve a result, but a duty to have regard to the need to achieve the results identified in section 149. Again, the court is not concerned with what would they have done, what weight would they have given to the considerations and the decisions, but have you had due regard? It's not a tick box exercise, and again, I'm not going to go through them individually. It's not a tick box exercise. And also, you can see crucially at number 4, generally speaking, and this certainly came up in Powell and Dacorum, generally speaking, if you have dealt with the matter at the possession claim, you shouldn't have to deal with it again at the execution of the possession order unless there's been a change of circumstances. And that mirrored and compared with the discrimination dicta along those lines in Paragon and Neville, which was, of course, Ryan's case. So those are the helpful, well, I've put them into 9 considerations that Mr. Justice Turner came up with. And then if we can go on to the next slide, please. We have Lord Justice McComb. Remember, he was one of the judges in Bracking, basically making the point, and I could have done it much simpler, I'm sure, but making the point that it's a question of context. This slide is subheaded context, because obviously, if you're going to be dealing with policies, whether they're national or local or even your own policies, if one's going to be dealing with policies, there's really no excuse not to properly have due regard to the public sector equality duty across the range of likely protected characteristics affected by whatever it is you're making the policy on. Whereas if you are, for example, a housing officer deciding whether, having got a suspended possession order because of antisocial behaviour, you should then move on to the next stage of a warrant or apply for the warrant because there has been an alleged breach of that situation, are you expected to go through the whole rigmarole again? And certainly Lord Justice McComb in Powell said effectively no, you're not expected to do that. But even if you were expected to do it at the earlier stage, i.e. at the stage when you're thinking about going for possession, it's a contextual thing. And therefore normally, if you've got somebody who has, for example, disabilities, and they are clearly causing, at least in part, some of the problems, and you have very much thought about that, you've spoken with support agencies, you've sought to engage, etc., etc. You've done all the normal things that good local authorities and housing associations do. Then in those circumstances, you've probably had sufficient due regard. In other words, you've considered the alternatives, you've considered what else you can do, you've considered the needs and the countervailing factors, such as the neighbours who are suffering from that behaviour, as well as, of course, as the individual tenant or their household who is causing the difficulties but may not be able to do anything about that. So it's a contextual question, and it's much more obvious and less rigorous in one sense in the context of individual decisions. Moving on to the next slide. These are the 5 cases. Now, at this point, this is when Rowan gets really panicky because he's doing the case law update, and I think he mentions 5 of these cases. So to be the nice guy for once, I'm going to leave Rowan to deal with much of this. Hertfordshire and Davis, which Riccardo mentioned, which I was against him on and other persons, is a case which is actually still ongoing. This is the caretaker case where the caretaker had lost his job and was in what we will call tied accommodation, had come up with various defences. I can't remember the number, but let me say 9. Had gone to the High Court because there was a declaration of incompatibility claim, and been before Mrs. Elizabeth Lang, and had not succeeded, and got permission to appeal on just the Children Act 2004, Section 11. In other words, a failure to consider the best interest of the children or the child, and had appealed to the Court of Appeal. The Court of Appeal in that case had decided, no, we're not going to do anything because you're a trespasser. You know, what good would it do? The fact that it hadn't been considered and those children hadn't been considered, you need housing, and the county council aren't going to be the ones to house you. You need to go to the local authority. Ultimately, they were evicted in February of this year, and they have brought an action to set aside the permission to issue a writ of eviction because of a breach of procedure. This was dismissed by the master, but they have sought permission to appeal. So it's ongoing. But it's also a case where they have raised the question of the public sector equality duty even at this late stage, and even though it was dealt with at the initial trial in 2017, and even though they had sought to get that to the Supreme Court on public sector quality duty grounds, and at least so far haven't managed to do that. The other case is, what they demonstrate is that they have public sector equality duty issues, both whether it's a mandatory ground case, such as Patrick, where the absolute ground was being pursued, or a discretionary ground case, such as Forward. So just very quickly going through, Dodana was a ground 17 false statement case. The judge was right to say there'd been a breach of the public sector equality duty, but she used the wrong test as to what the consequence of that was. In TM, it was a ground 14 case. The trust had rectified the breach of the public sector equality duty, which there certainly had been. And this was an interesting one because they had rectified it when giving evidence in the trial, which is an unusual response, but the officer clearly had considered the medical report and that was deemed to be sufficient for the public sector equality duty compliance. There is a permission to appeal outstanding on that matter. Forward was a ground 12 and 14, breach of public sector quality duty, but so what, as we'll see later, it was highly likely it wouldn't have affected the decision of the local authority. Patrick, as I say, absolute ground, very late pleading, very late disclosure of evidence for which you couldn't criticise the trust, and therefore a less formal approach was warranted. And in any event, there had been a formal assessment after the possession order was granted, and the appeal was dismissed by Mr. Justice Turner. And Powell is also still going on. It got to the Court of Appeal. Rucci and I dealt with that in the Court of Appeal application. It got to the warrant stage, no breach of the PSED. And they said that, well, in any event, the SBO had been agreed by the parties, which of course, subject to the court's approval, and disability had been raised at that point, albeit not the PSED, and therefore it was treated as having been dealt with at the possession order stage, and one shouldn't have had to go through it again at the execution of the warrant stage. I have to say it's still going on because a warrant was issued after the Court of Appeal and they applied to stay that. And although that was refused by the court, that's been appealed. So we're waiting for an appeal date on that. Next slide, please. Late compliance. This is just to make the fairly obvious point that you can have late compliance. Barnsley and Norton, that was under the predecessor legislation of the Disability Discrimination Act, Section 49A, said that they could rely on the local authority to comply with the public sector equality duty when they were rehousing the family through their homelessness powers. That was confirmed as an approach in Powell and Dacorum and in London and Quadrant and Patrick, and you can see the citation from Patrick below its reference there. Going on to the next slide, the effect of the breach. Well, this is only relevant, of course, if you actually haven't got compliance. If you've got compliance, that's fair enough. If you haven't got compliance, what the court should then look at is that would that have changed the decision? In other words, to be more precise, if it is highly likely that the landlord's decision would not have been substantially different if the breach had not occurred, there is no need to quash the decision. So in some cases, it wouldn't have made any difference, and that therefore it can be allowed to proceed even though there has been a breach. Next slide, please, which I think is the last slide. And this is just the use of the warrant stage. This is just to make the point that, of course, you can raise it at any stage. And as I say, they've sought to raise it in Davis. But it's much more difficult to do so because, as in most of the public law issues, that should have been dealt with at the possession order stage. And I've cited Patrick, Dacorum, and Hertfordshire and Davis to make that point. So if you're at the warrant stage, this is not to say landlords should just simply forget about the PSED, but really, unless there's something new that's come up, it should have been dealt with and raised by the defendant at the possession order stage. So I am now going to hand on, having probably ruined most of his contribution, to Rowan, who's going to be dealing with a case law update. Over to you, Rowan.
Thank you very much, Andy. Good afternoon, everyone. I'm going to talk you through some relevant cases in turn. And as Andy says, there'll necessarily be some repetition following the authoritative talks given by my co-speakers, but hopefully the next section will add some additional detail to supplement their presentations. I'm immediately going to go against the rule that all my case updates will be from the past year, because this case is so important to understanding disability discrimination in the context of warrants. And that case, as you'll see in the slide here, is Paragon ASRA and Neville. So in that case, the claimant brought possession proceedings against their tenant, Mr. Neville, who'd committed various acts of nuisance and harassment in breach of his tenancy agreement. These were admitted during proceedings, but Mr. Neville said they arose due to his disability, which was emotionally unstable personality disorder. He claimed that the possession proceedings unlawfully discriminated against him, as you, in the manner set out in Ryan's slide earlier, by an agreed SPO on the terms that Mr. Neville commit no further breach of his tenancy agreement. But it was noted that there was no disability discrimination in the making of that order. Although the possession proceedings amounted to unfavourable treatment, they were, again, referring to Ryan's introduction, a proportionate means of achieving a legitimate aim for the purposes of Section 15 of the Equality Act. So, unsurprisingly, ASB continued and Paragon issued a warrant for possession. The question that arose on Mr. Neville's suspension application was whether it was necessary for the court to consider whether the proposed eviction would discriminate against Mr. Neville on disability grounds, given the judge making the suspended order was satisfied that the SPO would not discriminate against Mr. Neville, and that there had been no material change of circumstances since then. The answer from the Court of Appeal was that you were not required to reconsider proportionality when enforcing a possession order, having previously done so when the order was made. Absent a material change of circumstances, a tenant can't require a court to reconsider that question at the warrant stage. So it's a useful case for landlords. It provides clarity and consistency in the possession process. And it also offers a guard against tenants attempting to reopen Equality Act issues, which have been decided definitively at an earlier stage in the proceedings. I almost said next slide there, but it's of course me doing the slides, isn't it? So next, I'm going to deal with Forward and Alwick, which Andy has already touched on. The landlord, as you've heard, brought possession proceedings on discretionary grounds 12 and 14, breach of tenancy agreements and antisocial behaviour on the basis of drug-related activity. Again, the tenant argued that possession of the property amounts to indirect discrimination, and he cited his severe back, hip and knee pain and pain along the right-hand side of his body as the relevant disability. The housing officer who made the decision to seek possession in the first instance had carried out a public sector equality duty assessment. He conceded in cross-examination that that assessment was necessarily inadequate because it lacked medical evidence regarding the tenant's disability, and the officer also conceded that he hadn't approached the issue with an open mind or considered alternatives. The tenant argued before the Court of Appeal that the breach of the public sector equality duty meant that the court had to dismiss the claim and set aside the order for possession. The tenant also argued that there were very specific factual circumstances where relief following a breach of the public sector equality duty could be refused. Finally, he also argued that it couldn't rightly be concluded on the facts of the case that even if the public sector equality duty hadn't been breached, that the possession order would inevitably have been sought and granted. Lord Justice Longmore dismissed the case and made the following findings. It wasn't the case that a breach of a public sector equality duty leads any decision following that breach to necessarily be quashed. It wasn't the case that only a narrow category of cases in which quashing could not follow a public sector equality duty breach. And as you've heard from Andy, and I won't repeat it here, the context was important when considering the extent to which the public sector equality duty was complied with or not. The court's required to look to the facts of each case, and if on the facts it's highly likely the decision would not have been substantially different if the breach had not occurred, there would be no need to quash a decision even where there'd been a breach of the public sector equality duty. And in that case, it was Forward, that is, it was the case that it was appropriate to find that the compliance with the public sector equality duty would have made no difference in any event. So it's not an excuse for public authorities and landlords exercising a public function to behave in a way so as not to give effect to the public sector equality duty, but it's an indication that more technical, arid defences on the basis of public sector equality duty compliance are unlikely to be successful. I'm going to move on to, that should be Dodana. Okay, I'll do Dodana. Oh yes, Dodana, yes. I'm going to go through this one quite quickly for the purposes of saving time. I know Dean wants to make sure there's time for questions at the end. This is effectively an application of the principle from Forward, in my view, where it's highly likely that an authority would have taken the same approach. Evidence of a public sector equality duty error will not result in the decision being quashed. Here, the tenant, Ms. Dodana, had admitted to obtaining her tenancy by fraud. The landlord had a policy of seeking to remove tenants who had obtained their accommodation by deception. And even though the public sector equality duty assessment relating to Ms. Dodana's mental health and that of her daughter, they were manifestly insufficient, the court was satisfied that the relevant characteristics of Ms. Dodana and her child were not sufficiently acute as to outweigh or counterbalance the trust policy of seeking possession in those circumstances. It followed that even if the public sector equality duty assessment had been carried out correctly, the outcome would have been the same. So that's just an application of the principle from Forward. Moving on to the next slide here, TM, a Metropolitan Housing Trust. So TM suffered from paranoid schizophrenia, and over the course of 2 years, he assaulted 2 members of staff and he exposed himself to a female resident. The Housing Trust commissioned an Equality Act report before seeking possession of the property, and that report recommended seeking possession, but it did seek additional information as to the tenant's capacity. What happened next was that the landlord proceeded to seek possession despite not obtaining this additional information in relation to capacity. But when yes, and then after the possession proceedings had been initiated, then the defendant, the landlord received additional information about capacity from a psychiatrist. So the trust then didn't carry out any further assessment of the appropriateness of seeking possession after receiving the additional information. But as Andy said, the officer agreed in cross-examination that had he had the information, he may have taken a different approach, but he considered, notwithstanding that failure and the failure to consider the additional information before making the decision to seek possession, he considered that the decision to seek possession was in any event proportionate. So the grounds advanced in favour of TM were that the trust had breached the public sector equality duty, and that the decision to commence proceedings amounted to unlawful discrimination arising from a disability. At first instance, the recorder made a possession order and he found that the trust had breached its public sector equality duty by failing to review its decision in light of the further information received from the psychiatrist. But he held that the officer had rectified that breach during the course of his oral evidence when he stated that he considered the decision to seek possession was in any event proportionate. The judge found that the decision to seek eviction amounted to less favourable treatment, but again, harking back to Ryan's slides at the start of the talk, this was a proportionate means of achieving a legitimate aim. Again, TM appealed to the Court of Appeal. The Court of Appeal dismissed his appeal, and they added on the discrimination point that there was no alternative to the possession claim because they previously sought a different approach on the basis of the first assault by the claimant, but that hadn't worked, and ASB at the property had continued. On the public sector equality duty point, the court noted that in any event, the breach had been remedied during the officer's cross-examination. Applying the decision in Forward as well, they found that despite any public law breach, it was highly likely the trust would have pursued substantially the same outcome. So I'm just mindful of the time now. I want to make sure that there's time for questions. So turning on, I've got 2 more. Turning on to Powell, again to supplement Andy's remarks about the importance of context when considering the public sector equality duty. Here, an SPO was made due to both rent arrears and convictions for drug related offences committed at the property. And as Andy stated, the public sector equality duty was not raised at this stage. 3 months later, following the SPO, there were more allegations of drug offences at the property, and the authorities sought to enforce the SPO. The tenant applied to suspend the warrant, but again made no mention of the public sector equality duty in that application. The court directed that the application for suspension be adjourned for a full day's hearing. Around the time of the application, it was adjourned as a psychiatrist suggested that the defendant was too mentally unwell to participate in the court process. The defendant's doctor wrote to the claimant informing them that the defendant suffered from psychotic illness and a depressive episode. At that stage, the claimant then performed a proportionality assessment in light of the additional information that had been provided, but it concluded that in any event it was necessary, proportionate and reasonable to seek possession. At the first hearing, the court concluded that public sector equality duty did not provide grounds to suspend the warrant. Circuit judge in turn dismissed the tenant's appeal, and the Court of Appeal eventually agreed. Given what was known to the landlord at the time they sought the warrant for possession, it would have been unfair to say the landlord hadn't complied with the public sector equality duty. The tenant had agreed to an SPO without having raised any public sector equality duty questions. The situation in a way was quite similar to that in Paragon and Neville. There was no reason for the council to think it was no longer entitled to enforce the order, either due to non-compliance with the public sector equality duty or otherwise. Further, attempts had been made by an officer to find out whether circumstances had changed. Nothing new was revealed until new medical information was provided during the course of the application for suspension of the warrant. When that information came to light, the landlord immediately considered the proportionality of its approach. It expressly mentioned public sector equality duty and considered its position accordingly. So even if there had been a breach of the public sector equality duty, it had been remedied by this later proportionality assessment. And that's a point that's worth noting in continuity with Patrick, which I think is my final slide. Again, you have the contextual point, but I won't labour because Andy's already explained it. Moving on finally to the final slide. Patrick, yes. Moving on finally to Patrick. The defendant had caused nuisance to his neighbours and officers of the claimant, and the claimant had obtained an injunction against him. The claimant had already at this stage issued possession proceedings, but permission was granted to rely on the additional ground for possession under ground 7A of the 1988 Act. The defendant filed a defence which for the first time alleged a breach of public sector equality duty engaged by reason of the defendant's paranoid schizophrenia. It also alleged unlawful discrimination under section 15. At the first hearing, the claimant sought summary disposal of the claim. The defendant sought directions to trial following the issues that he'd raised in his defence. The judge determined the point was not genuinely disputed on grounds which appeared to be substantial under CPR Rule 55.8, and he made an order for possession suspended for 6 weeks to take into account of the defendant's disability. An officer of the trust then carried out the exercise of conducting detailed written public sector equality duty assessment, which concluded that the trust would be justified with regard to its duty under section 149 of the Equality Act to enforce the possession order. The defendant appealed. The sole ground of appeal was whether permission, the sole ground of appeal which was granted permission rather, was whether the defence advanced under section 149, the public sector equality duty, required the judge to give directions, or whether it was still appropriate to dismiss or dispense with the issue at the first hearing. In the course of quite a detailed judgment, the court considered both Powell and Forward. The court found that the trust hadn't breached public sector equality duty. The issue of the defendant's disability and relevant medical evidence had only been provided by the defendant very late in the day, but when they had arisen, the landlord had considered the disability and concluded that it was appropriate in any event to pursue a claim for possession. Quite usefully, is quite a useful phrase used in this judgment, the duty was not the trump card, which required giving of directions rather than summary disposal of the issue. The court did note that the position could have been different if the tenant's disability had been apparent at an earlier stage. If that were the case, then a more detailed consideration would have been necessary. But on the facts, given the late nature of the information relating to the public sector equality duty, the landlord had given appropriate consideration to it on a continuing basis, applying the decision in Powell. In any event, the decision had been superseded by the landlord's later detailed assessment, and with reference to the decision in forward, it was highly likely that the decision would not have been substantially different, even absent any breach. And so that's, I'm sorry I've overrun slightly, Dean, but that is my my case law summary, and thank you very much for your attention.
Rowan, how could I not forgive you the slight overrun when that talk has been, I think everyone will agree, both informative and very interesting indeed. That, with the end of Rowan's talk, brings us to the end of the formal presentation itself. But unsurprisingly, perhaps throughout the course of the talk, we've had a series of questions put on the chat forum. And what I'm going to attempt to do now is something which I confess has previously escaped me and proved beyond my Zoom capabilities, which is to share my screen when one screen is already being shared. And in fact, it tells me I can't do that. It's not my fault, it's Zoom. So instead of that, I'm going to simply read out a series of questions that I've filtered for relevance and that I consider we are able to answer during this session, and I'll read those out to you in succession. So the first of them, which I will attempt and answer first before handing over to the panel, is hoarding a disability? As far as I understand, the current medical position on hoarding is concerned, is that it is increasingly recognised as a disability in its own right. From a legal perspective, it is not, however, in principle recognised as necessarily a disability under the terms of the Equality Act 2010. It may, however, well be a symptom of one or more mental impairments or behavioural impairments which themselves constitute a disability within the meaning of Section 6 of the 2010 Act. And so ultimately the question legally in any case which involves hoarding will be whether either the hoarding itself or perhaps more pertinently the mental or behavioural conditions that result in hoarding themselves amount to an impairment which has a long-term and adverse significant effect on the ability to carry out day-to-day activities within the meaning of Section 6. If it does, it's likely to be a definition, it's likely to fall within the definition of disability legally and therefore to qualify as a disability. That, as I understand it, is the position. If any of the panelists take a different view, feel free to shoot me down in flames now. Silence came the loud reply. That's filled me with confidence. In which case, let's leave that question there and turn to the second question, which is, can a tenant who did not raise a disability discrimination defence at the possession order stage, such that a possession order was granted without consideration of disability or discrimination generally, raise that defence to avoid the execution of a warrant once that warrant has been obtained? And I believe that Andy has had recent experience of this, so let me hand over to him in the first instance.
Yeah, I think this is Jensen's question, so thank you very much for the question. I mean, it's obviously a slightly different factual basis than Powell and Dacorum, where, of course, disability was raised at the first instance when the suspended possession order was agreed by the both legally represented parties, albeit PSED wasn't pleaded in the defence. In your question, Jensen, you're assuming that it wasn't raised at all at the first instance. But it seems to me there is a greater problem, which is that one of the things that Lord Justice McComb said is that, well, wait a minute, you're accepting that the possession order is a valid possession order. Don't know what's just happened there, but you're accepting the possession order is a valid possession order, and you haven't sought to set it aside. And therefore, it seems to me that if you're accepting it's a valid possession order, and if you're dealing with an absolute ground, well, that's very good, you're dealing with an absolute ground, then it's difficult to see what powers there are to stay execution. If you wanted to say that there should be a set aside of the possession order as well, then that may be different. But remember, right back from authorities such as Southwark and St. Brice, there is clearly the key issue, which is the possession order, and then there is the enforcement of the rights which have already been determined at the possession order stage. So I suspect we're not going to agree on this, Jensen, but I would certainly argue And it depends on the facts of the case, let's be blunt about it. But I would certainly argue that if you have got an absolute ground possession order or a mandatory possession order for on some other basis, then you're entitled as a landlord to enforce that order unless and until there is an application and a successful application to set it aside, and that the PSCD won't help just at the enforcement stage. But it's not actually being decided on the precise facts as you've cited, but I would extend the Powell and Dacorum principle and the remarks of Lord Justice McComb.
I think there might also be a point here about abuse of process, because of course, if there were facts which were relevant at the point that the defence was put in by the tenant, then those really ought to have been raised then. If there was then a subsequent change in circumstances, I can see a very strong argument for saying that those can be raised at a later stage. But if they are simply raising things after a possession order has been granted, which could have been raised at an earlier stage in the proceedings, then that sounds to me very much like an abusive process.
Well, also, of course, what we're talking about potentially is somebody who wasn't represented, who then goes to the solicitor or the advice service after the possession order. And therefore, perhaps understandably, the tenant didn't raise it or didn't engage with the process for whatever reason. But I agree with you, Ryan. I don't think it gets around that fundamental problem. You've still got, even if you were dealing with it as a suspension of warrant, you've got a valid possession order until it's set aside. So unless you attack the possession order, then what you've got is a determination from the court that the landlord should be entitled to possession on a mandatory ground with the normal Housing Act 1980, Section 89, 6-week time limit. And we all know from Hounslow and Powell that even the convention won't assist you in that. You know, so I just think that you have to attack the possession order. Not that I'm saying that that's possible, but you'd have to attack it rather than just deal with it as a warrant hearing.
Yeah, I think the principle to which Ryan referred is embodied in the case of Henderson and Henderson, which states that really the party should bring all of the issues that are pertinent to litigation before the court at the time the litigation is decided. And I agree with Ryan also that actually, if in fact it is a new issue which has arisen since the possession order was made, that may well in fact give ground for raising the argument at execution of warrant stage, or at least seeking to vary the possession order in light of changed circumstances. It cannot be right that, for example, if somebody becomes disabled and therefore would suffer discrimination as a result of execution of a warrant, that they should not be able to raise that if indeed it's a new consideration, a new circumstance that's arisen since the possession order was made. That to my mind would result in serious injustice. Let's move on from that question, however, and consider the third question, which I know you'll see because I've no doubt Rowan's taking the slides off screen, up on the screen itself. So how might a registered provider be liable for harassment in the exercise of its functions? And can you provide an example? Now, I'm aware that Ryan's already answered this online, and I'm going to say something before I hand over to Ryan. And I entirely agree with him that it is very unlikely indeed that this is a scenario that would generally arise. It doesn't mean to say it's not an allegation that might be made. And in principle, as far as I'm aware, applying Section 26 of the 2010 Act, a registered provider might be accused of or held liable for harassment in respect of a disability or other protected characteristics under the 2010 Act. So in principle, Section 26 would provide the legal forum or route to that argument, if you like. But in practice, I certainly have never seen that alleged. It's usually Section 15 disability discrimination in the context of the management of premises under Section 35. I think, Ryan, you might have had a case which may or may not have raised this in front of one of the Midlands judges that may have gone on to appeal.
Yes.
Perhaps you'd like to say a bit more about it.
Yeah, that was a case on behalf of a housing trust, an RP, who had unfortunately not investigated allegations of ASB as assiduously as they might have done. Although our view throughout was they had done enough, the judge clearly took the view, both at first instance and then the judges of the Court of Appeal took the view that really our inquiries into the alleged ASB were simply not rigorous enough. But it was worse than that because, of course, there were allegations behind the scenes that this particular tenant who was alleging harassment against the landlord, there was a suggestion that that individual had been involved in activities which might suggest that he was likely to commit offences against children. And that, because that spectre had been raised and because we didn't investigate it as rigorously as we should have done, and took action by writing letters saying, you know, your home is at risk and so on, the judge took the view that an incompetent investigation coupled with a stick such as threatening to take possession proceedings could amount to harassment under the Protection from Harassment Act. So this wasn't an Equality Act case, it was a Protection from Harassment Act case. But that is an extreme example where the facts were extreme, the investigation wasn't as rigorous as it should have been, and there was this suggestion that this individual's character was being besmirched. And we as the authority should have done more to investigate those claims properly before we made the threat to issue possession proceedings. So that was all in the context of the Protection from Eviction Act. Those were very particular facts, very unlikely to arise again, I think, because of the nature of how it all came together. But it's still a good point to be aware of. You don't want to be stood accused as an RP or a local authority of harassing your tenants. And you should be aware that one of the ways you can find yourself in that position is if you conduct an investigation which is not as rigorous as it should be, and then you threaten possession proceedings.
That's very helpful. Thank you, Ryan. Anyone else want to add? We move to the next question. I'll take that as move on. So when completing a PCOL application, would you specifically mention that the landlord has had due regard to any known disabilities and to the PSED? Who would like to take that question?
I've answered that in writing.
Okay.
My answer was, if you have knowledge of a vulnerability or a disability, it's best to meet it head on. No one's going to be served by the landlord pretending that it doesn't know about the tenant's circumstances, and the landlord saying, I know about these circumstances and this is how I've considered them, is only going to be helpful to the court and to the parties. I don't remember how much space you get on a PCOL form. So it might be that it's the sort of thing that needs to be put in evidence, either with the PCOL form or afterwards. But the sort of the principle is, yes, address it. Don't just say the defendant's circumstances.
I'd be inclined to agree with that. Yes, so it's known circumstances. As I say, I'd be inclined to agree. I think probably the position is you're not bound to refer to them, but as Riccardo rightly says, if you want to demonstrate to the court, in case such a defence or counterclaim is raised, that you have in fact had regard to these considerations at relevant points in the decision-making process, then it can do you no harm, I would imagine, and in my view, to make that clear on the PCOL form itself when the claim is first issued. I don't recall, it's been a while since I've looked at a PCOL form, how much space there is, but conceivably you would be able to, as Riccardo rightly says, either reduce that in evidence in support of the form itself, or perhaps even add a rider. Therefore, moving on to the next question. Are public law defences available in claims against unauthorised occupiers and failed successors? I don't mind having a first stab at this before I hand over to the panel, because in principle, of course, they are. Where a public body makes a decision which leads to a decision to recover possession of residential premises, in principle, on the authority of Wandsworth and Winder, that decision can be subject to public law challenge in the same way as it might be the administrative court. Whether and to what extent it makes any material difference in claims against unauthorised occupiers and failed successors is another matter. And of course, that will depend on the facts. But of course, in the context of human rights, we have authority in Pinnock and the authorities that followed it, in particular Andy's case of West Kent and Haycraft, in which it made very clear that certainly in the human rights context, arguing Article 8, for example, would be very unlikely to avail those who had no contractual or other security of tenure at residential premises, and therefore that kind of public law argument in defence of such a claim would very probably fail. Whether it would fail if you raise traditional judicial review grounds, as I say, would rather depend on the decision, the failures and the facts of the case. Any other panel?
In the case that Riccardo and I were in on opposite sides, Hertfordshire and Davis, Mrs. Justice Lang had said that you couldn't raise, or she indicated that you couldn't raise a public law defence when there was no private law right. And obviously, in Mr. Davis's case, he was no longer a caretaker. He no longer had any right. He was a trespasser. When we got to the Court of Appeal, they weren't very interested in hearing from me on the substance of the appeal because they probably had already decided that. But on that question, they just said, "Well, do you agree?" And it wasn't an issue we'd raised, but I foolishly said yes, and they obviously explained to me why I was wrong. And gave the examples of, for example, a lot of these traveller cases, of course, are raising such issues and quite legitimately raising those kind of issues and are being dealt with by the courts. I think it's more interesting, you can raise them definitely, but I think it's more interesting in the case questions of successors, or I should say, of course, failed successors, because there may be more traction there. I still think it's unlikely to succeed, but depending upon the facts, there may be a little bit more traction in those kind of cases than otherwise. But yes, you can certainly raise it.
Excellent, thank you very much. So moving on to the next question. What is the best course of action to address the antisocial behaviour of a tenant who may have a mental impairment, but whose behaviour might also be a consequence of drug misuse, where the landlord is unable to get social, medical or mental health services to engage? How might the landlord best avoid discriminating against the tenant? Who would like to offer the first answer to that?
Yeah, I'll give it a go. I mean, this is the gritty reality, I think, of dealing with these cases. It's all very well us sitting in an ivory tower and telling you that, of course, you should contact mental health services and get them to engage, but we all know that it's not that easy. So there are cases such as this, which the questioner describes, where it's the mental health services that aren't engaging rather than the tenant. In a situation where you're simply not sure whether it's the alcoholism or some sort of underlying disability which is causing the behaviour that's leading you to take the unfavourable treatment, you should proceed on the basis that the disability conditions are satisfied within Section 6. And so what you will be doing is making a careful note of all the actions that you're taking to try and get mental health services to engage, trying to get that individual to go to their GP, doing all the signposting that you can do, making the referrals that you can make. And so long as you've documented all of that and proceeded as if that is an individual who is disabled, then you are ultimately going to be protected if it transpires that this individual is disabled, or the allegation is that you ought to have known that the individual was disabled from facts that were available to you. So it simply can't harm you if you proceed on the basis that this is an individual who is disabled, and if you take a proportionate approach. That's how I would do it.
I also think that there is some, if you're represented as a defendant, there is an onus on the defendant's lawyers to have a think about how they address it, because I've certainly dealt with several cases, and I know I've spoken to Dean about this on occasions, and he's had similar cases, where actually the problem isn't the landlord who's been doing absolutely everything right. Arguably, it's not even the tenant, because they have their own issues. It's the fact that maybe the relevant services are not cooperating and are not helping at that stage to the point, to the extent that they should, and that maybe therefore the litigation should at least in part be directed towards those agencies as to why they're not carrying out an assessment, as to why they're not engaging with the individual, etc., etc. And although that doesn't mean that you don't pursue a defence, of course, it does mean that there's something proactive going on, because I've dealt with several cases, and I've got cases to come, where everyone accepts the accommodation for the tenant is unsuitable. Yeah, they cannot stay there for whatever reason. They just simply cannot stay there. and everyone accepts that it's not the landlord who is the person who's going to have responsibility for placing them in their next accommodation. Well, you're in a difficult position then, because the landlord can't do anything about it, the tenant can't do anything about it, the court can't really do much about it, unless, of course, they make the possession order and put it at the door of the other services and say, look, guys, you ought to be doing something. But I do think, and I appreciate legal aid is very short, and I appreciate that there's not many people around with the franchise to give that advice. But I do think there ought to be more efforts made against those bodies who ought to be providing the support other than the landlord.
Yeah, I think the message as we part company with that question is protect your position. As Ryan says, assume that the disability exists. Take decisions based on proportionality based on that assumption. And if in the course of litigation, a disability discrimination defence or counterclaim is raised, you will then have the evidence to demonstrate to the court that you have nonetheless considered it at all relevant points and that your decision making is proportionate, irrespective of that and the circumstances changing. So last question for today's purposes, because I can see that we are approaching 4:30. If a defendant raises a disability discrimination defence but adduces dated evidence of their disability, for example, evidence that is 4 to 5 years old, could a landlord argue that the existence of a disability has not been proved? I think the answer to that, we can probably agree, is fairly short. In principle, yes, it could be argued that disability has not been proved, depending on the evidence and the circumstances. If in fact you have, for example, a tenant on whom the burden of proof rests in proving a disability, who can only demonstrate that, for example, 5 years ago they suffered from depression but has adduced no current evidence of that mental impairment, then you might well argue that in fact there is no evidence before the court to indicate that that condition is ongoing, and therefore that the burden of proof has not been discharged. Much as I say will depend on the facts and on the evidence. It may well be that that 5-year-old evidence says in terms that this is a lifelong condition from which there is no real cure and from which the defendant will suffer. In that case, you may be in difficulty. But if in fact it is, by contrast, a periodic episode of let's say, mild depression, well, it may be a very different case, and you may therefore have an argument that that burden has not been properly discharged. Before I close today's webinar, do we have any further additions or comments on that last question? And if not, then it falls to me to say on your behalf, I'm sure, thank you to each of our speakers today, who unsurprisingly, to both me and you, I'm sure, have provided us with both an entertaining and educational experience in their talks. Thank you for joining us. Please sign up for tomorrow's webinar, the last in our housing law week of webinars. We'd be delighted to see you registered for that event. And in the meantime, thank you for your participation and your interest in Cornerstone. We look forward to seeing you and speaking to you very soon. And of course, dare I say shamelessly, to your future instructions. Stay safe, and we look forward to seeing you soon. Thank you very much.